Aloha, everyone. Welcome back to the negotiation table. My name is Wincy Hong, your host and communication specialist here at HGEA. With us today, we have Randy Pereira, Executive Director of HGEA. Welcome back to the podcast.
Thank you.
Before we dive into this month's conversation, don't forget to hit the like and subscribe button so you never miss an episode. All right, let's dive in. The 2026 legislative session wrapped up earlier this month, and HGA scored a few significant wins for members. These include a bill to increase the maximum contribution and carryover amounts for public service flexible spending accounts, and a bill that would address the rising problem of educational employees facing harassment. The legislature also confirmed a new labor-friendly Supreme Court Chief Justice. So, Randy, let's start with the Flexible Spending Account Bill. Some people may not understand why this is such a big victory, and maybe you can break down what the status quo has been for so long and why this change is going to be a big benefit for public sector employees with the state.
Well, certainly. It's been a long time in coming. The federal government allows employees to deduct pre-tax their medical premiums, among some other things. And for so many years, the state has chosen not to keep up with the IRS schedule that allows for a gradually increasing amount every year and the amount that you can deduct pre-tax. Bottom line, this is going to save members money from their taxes because now, effective July 2027, and why the delay, I'm not quite sure. I think it's just more de-herd inertia, frankly. But now, beginning July 2027, our members will be able to deduct their premiums pre-tax, and it should save them a fair amount of tax liability. My understanding is right now, the state is something in the neighborhood of $600 to $700 a month behind what the city and county allows. It's a significant change, and we're very, very pleased that the legislature has seen the wisdom to go ahead and force it.
Absolutely. This session, we also saw several bills intended to address school employee safety following the assault on Natalie Iwamoto, Associate Athletic Director at Moanalua High School. 3 bills passed, including one named after Natalie, that makes harassment of education and public employees a misdemeanor. The AG is also given authority to help employees obtain TROs. Can you talk about why this is such a major win?
Absolutely. This has been another of those long-term fights that our organization has had. And sadly, when we see the level of violence at schools on the continent, we've come to fear that in many instances it may be a matter of time before we see an escalation of violent behavior here. And to some extent, I think we have with this incident at Moanalua High School. I trust that Natalie does not want this bill named after her, even though that's what people are attributing it to, but most certainly appreciate her advocacy and pushing for this, given the traumatic situation that occurred to her. It's been our position that the state has just not provided adequate support and protection to those individuals in the wake of assaults. Certainly, we would want greater security at all events, but where that's not always possible, very clearly when something bad has happened, we have seen the state shrink away, largely, we believe, just to avoid potential liability. But we've seen the state shrink away from helping employees obtain restraining orders or even attempting to prosecute the individuals who are the perpetrators of this violence. Now, I think, and sadly, it came to this event, but now I think we're in a better position, one, to see the Attorney General actually assisting employees rather than those employees having to secure legal counsel and pay out of pocket for that expense. And we should see as well a greater emphasis on providing safety plans for individuals who are the victims of these kinds of incidents. So it is, in fact, it's too long in coming for sure, but it is a great victory. Sadly, though, we're still living in an environment where the prevalence of violence is just so great, and we're going to continue to advocate for greater safety measures to the extent that we can. But at least now we've got something in the aftermath of such a tragedy where there's a positive outcome potentially for employees.
Definitely. 2 years ago, Governor Josh Green placed Vlad Devins on the Hawaii State Supreme Court as an associate justice. At the time, you said this was a historic moment for labor in the state, marking the first time an advocate for workers and organizing would be on the highest bench. This session, Devins was confirmed as Supreme Court Chief Justice. What will this mean for the labor landscape for the decade or so to come?
Well, most certainly, it is, in fact, a great thing. We were fortunate to see two very good justices competing for this position. Justice McKenna, who was the acting Chief Justice, and Justice Devins. What Vlad Devins brings to the High Court as the Chief Justice really is twofold. One, he is someone who understands, having worked with labor unions practically all his career, he is somebody that understands issues facing working people. And while his opinion is not going to be a gimme, he still has a lot of other things, the public interest among them, to consider in any decision. We're at least assured that we have somebody with a labor background that can understand how legislation and or the law affects individuals, workers, and the unions, and therefore at least somebody that we can bank on to be sympathetic, if you will, and understand our issues. At the same time, he becomes the administrator of the court system, and that is particularly good for us because we have enjoyed a great working relationship with now Chief Justice Devins, and he will be running that third branch of government as the employer by statute. So we will now have to deal with him on labor relations issues. And we're very confident that for the employees of the judiciary, we can say that we expect a fair shake from him and a good working relationship going forward.
Let's switch gears to some of the lowlights of the session. Lawmakers passed a bill that sounded good on paper, minimizing the impact of Citizens United and dirty money in our politics. But we're now finding that this bill, signed into law by Governor Green, has some major consequences on unions, particularly when it comes to endorsing candidates. Can you tell us about this?
I think the bill certainly was well intended, and it's part of an effort that includes other states like Oregon, most prominently, that have attempted to regulate what we call the black money, the dirty money in politics. And we've seen evidence of that dirty campaigning here in Hawaii. Well intended, though, it was hastily put together at the end of session. And I think despite their intentions, the final product may end up having provisions that will be rather harmful, particularly to those of us in the public sector. As intended, the bill regulates spending. Effectively, it eliminates the spending by so-called artificial persons or corporate entities and would prohibit them from spending any money on political elections or ballot initiatives. As intended, perhaps that's fine. However, most every union in Hawaii is in fact a nonprofit corporation chartered by the state. And the language of the bill appears to prohibit those entities from doing any what they call electioneering. Electioneering is a broad term, and that would include more than just spending money. So for us, we are in the process of reviewing the language of the new law and consulting with attorneys from both the AFL-CIO and AFSCME in Washington, D.C., to determine the full impact and understanding the interpretation of how this law can be implemented. At its worst, it could prohibit any union from even having a political action committee and endorsing candidates. And while that might be music to some of the ears of some of our members, let's face it, who just don't see the value of politics, it cuts both ways to us, because on the one hand, certainly when we endorse candidates, we're trying to make sure that we elect people who will be understanding and sympathetic to the concerns of workers. And at the same time, just witnessing what we're seeing in Washington, D.C., we sure like to be able to tell our members who not to vote for when it comes to future elections. So right now, we're kind of in a holding pattern as we come to understand the bill does not take effect until July 2027. So there may well be time for the legislature to amend. I think legislators are now waking up to the reality that this perhaps is a bit more broad than they had intended, and we'll see. But for the time being, it does appear that the ability of any union to be involved politically has been severely limited.
HTA members, particularly our educational officers in Unit 6, fought a massive battle against HB 3334, which would have changed the way principals and vice principals are selected and evaluated. It would have changed the organization of DOE by eliminating complex area superintendents. Can you take us back through that fight and what made the difference here?
The legislation as it was originally drafted was intended to address what the legislature felt was too broad an authority by the superintendent to appoint individuals. There were no statutory limits on the number of individuals that the superintendent could appoint. So they chose then the path of trying to scale that back by eliminating the complex area superintendent positions and going back to an old district superintendent model, which had been abandoned several years ago. But in addition, the greater concern that didn't make the headlines so much was what you suggested in your question, which was changing the manner in which principals are selected and evaluated. And that, for us, is a matter of collective bargaining. It's a contractual issue. So our immediate reaction to the bill was to say no, clearly, because it infringed on what we have in our Unit 6 contract with the DOE and the state. In the broader picture, we felt that it was unfortunate that the legislature was going down this road to address their concerns about the superintendent's authority, and felt that the CASs, however imperfect the system may be, at least provided closer to ground level for the schools an ability to address issues without having to go higher up into the system, all the way to the superintendent's office. So we mounted opposition, and what came from it was, one, an amendment to the bill, which was obviously welcomed by us, and the distasteful parts were taken out, the objectionable parts. But I think of greater value was the fact that it energized a lot of our members in the DOE, not only in Bargaining Unit 6, but in the other units as well, who came to see that by rising up and speaking out and not being afraid of retribution or bad conduct by different legislators, they could see that they did have the ability to influence how the legislation would ultimately go. And this takes me back to the question that you just asked about the new law regarding electioneering. Clearly, this would not be happening if we no longer had the ability to either support or oppose different candidates running for office. But in this case, it was proven that public employees, particularly in the DOE, had some friends who would then attack the problem that they saw about the superintendent's powers, but without trying to make trouble changes to other things, in particular, infringing upon our bargaining rights. So, really, kudos to all of the folks who showed up in person or the people who submitted testimony online. There were hundreds of pieces of testimony. And frankly, I think it really energized our members to understand that they have a say. And they chose not to just take this lying down. And I, for one, am grateful, not just because we were able to stop a bad bill, but because I think to all of those people who participated in this process, there's now this new realization that, hey, one voice does count. And a chorus of voices that all of us make up really can matter. And on a going forward basis, I think that's the most important thing for all of us to realize, that we can be energized and actually, we can actually influence the way things turn out.
Absolutely. There's a strength in numbers.
Absolutely.
Several of our bills didn't survive. Can you talk about what a huge blow this was for our members?
Well, you always live to fight another day, but some of our legislation did not pass. Specifically, we did have one bill that was regarding what we call indebtedness, where individuals are overpaid by the employer. And our legislation, proposed legislation, I should say, would have kind of softened the blow and placed some limits on the repayment schedule. Still got to pay it back, but at least would make payment terms easier. That didn't survive. Once again, we were pushing hard to make EUTF plan and contribution subject to arbitration, which has not been the case since the EUTF law passed in 2000. We got all the way to conference committee, but again, that did not pass. And maybe most disappointing were two bills. One that would have addressed the reimbursement time for people who travel on government business. We've seen, and there are horror stories of some employees who are required to travel for work to conferences or meetings on the continent or elsewhere. They've waited 8, 9, 10 months for reimbursement, paying the exorbitant interest rates on their own personal credit cards, and waiting in vain sometimes for reimbursement by the state. Our members shouldn't be creditors of the state. And legislators fail, despite how many legislators travel with frequency, I'll add. Our legislation failed that would have provided for a more expedited payment process to reimburse these individuals. So we're going to try again, for sure. Most disappointing was the bill that would have addressed what we have known to be repricing in the past, where we have attempted to bargain the pricing of occupations in state government along with county and the judiciary, and looking at market factors where very clearly the government pay scale has just not kept up, and we see great vacancy rates and attrition because of it. The bill would have reduced the required bargaining period and would have streamlined the arbitration process, where we would be able to utilize local arbitrators to deal with these disputes rather than having to go through the American Arbitration Association and likely getting somebody from the continent to adjudicate. So that particular bill we viewed maybe a little bit more than a housekeeping measure, but it was intended really to streamline and actually save both parties money, because you would no longer then have to pay the travel costs and the higher fees that some of the mainland arbitrators will charge, and we could instead use local folks who are probably even better versed in market conditions than anyone else. That bill failed because Senator Donna Kim, who was the manager of the bill from the Senate Ways and Means Committee, just simply chose not to show up and vote. She was in the building, prancing around, I understand, but she just chose not to show up. And it's very unfortunate because, frankly, that's her job. Her job is to be an elected representative, to show up and vote. But be that as it may, we're going to try again, no doubt, and we're going to continue to press forward with the cases that we have pending now. Unfortunately, though, without this change in the statute, the process will just continue to take a long time, simply because you're now trying to deal with the schedule of somebody that might live in California or points beyond, and it's not quite as easy to get on that person's calendar.
While we have you here, we had plans to announce our support for Lieutenant Governor Sylvia Luke, who most people now know has withdrawn from the Lieutenant Governor's race. Luke has been a big supporter of HGEA. During the pandemic, she was instrumental in ensuring the state would have the money to pay for temporary hazard pay for state workers. How big of a setback is this for labor, and where do we go from here?
I suppose we could be talking about this for the next couple of hours, but it is a most unfortunate set of circumstances, and I had anticipated our viewers have perhaps in their own minds formed certain conclusions about how things have played out. There are allegations hanging over Lieutenant Governor Luke's head at this moment, and it's probably not wise to be commenting and creating controversy simply by addressing those kinds of things. The bottom line is that the circumstances have led her to withdraw from this race, so she will not be a candidate in the primary or in the general election. And at this moment, there are two candidates, I understand, two prominent candidates who have pulled nomination papers looking to run. Our organization, as well as a lot of others, are going to take a look at the race and see what path we choose. Our board will ultimately have the decision. I realize that there are mixed feelings perhaps out there. There's no question that Sylvia Luke has been a staunch supporter of public employees and of HGA in particular. I would be remiss if I didn't say to her, not that she may be listening, but thank you for all that she has done, because her contributions to those in public employment have been significant. I would add, just as an example, she almost single-handedly stopped Governor Ige from furloughing employees because she found ways to finance state government and ensure that our members would keep working and act as consumers during the pandemic and not be sitting at home without paychecks. We'll just have to assess the race going forward, see if anybody else jumps in, and see if there's somebody out there that our membership would consider supporting. But for now, we wish her well and hope things turn out the right way.
All right, Randy. It's always great having you here. Any final thoughts?
No, I think the next couple of months will be very interesting. We will see, for example, if anybody jumps into the lieutenant governor's race. We do have elections coming up, certainly, which will be a lot of fun, as they always are. But we're also going to see unfolding the continuation of these investigations that are happening in our government, whether it's the aforementioned situation with Sylvia, or now people looking at expenditures for the homeless Kauhale and other things. So promises to be a pretty interesting time, if nothing else. If only we could get the Attorney General to actually move with some speed and priority, who knows, maybe things could go, maybe the outcome would be quicker, but it'll be fun.
Yeah, we'll just have to see.
Right.
Well, mahalo, Randy, for being on and joining us at the negotiation table.
Thanks for having me again.
Join the conversation, everyone. In the comments, let us know if you are a school employee who is breathing a sigh of relief after the passage of Natalie's bill. And are you glad the legislature finally addressed the maximum contribution for flexible spending accounts? And for more content like this, don't forget to like and subscribe. Until next time.